Welcome to Legis Finance's launch event. We've had a symposium today about damages-based agreements, and we're extremely fortunate to have with us now Professor Herbert Kritzer, Sir Rupert Jackson and Professor Dominic Regan. And we're just going to have a quick chat following the day's events, try and draw together some of the themes for those who perhaps missed it. And Tom's going to be asking the first question.
Thank you. The title of the symposium today was The Promise of DBAs, and it wasn't something like DBAs, the monster that ate the English legal scene, which would suggest possibly that expectations about DBA use haven't been met, and I think probably people would agree with that. But what I'm curious about is, what were the expectations when they were introduced? How did you think that they were going to be taken up and used by solicitors?
Well, I'll go first perhaps. I was proposing to cut back the CFA regime so that parties with conditional fee agreements could not recover their success fees and their after-the-event insurance premiums from the other party, because I thought that regime was iniquitous. I was keen to maximise the different ways of funding litigation, and I was aware that a number of people currently using conditional fee agreements would wish to switch to another form of funding. I therefore sought to promote new ways of funding, one being an increase in before the event insurance, another being a greater use of properly regulated third-party funding, and a third and very important one being the introduction of damages-based agreements, which were not at the time of my report allowed, but which I thought were very necessary and would promote access to justice.
And Dominic, were you surprised that they didn't get a bigger uptake than they did?
Not at all, because the reason why is that the government ignored, of course Sir Rupert was the architect, but they ignored his plans. And with that, they prevented solicitors acting on a DBA except where the solicitor took all the risk and the client had no exposure, and only a fool would run a case in those circumstances. So it was from day one, once we had the regulations, it was unworkable.
But the good news is it looks like we're going to be getting an announcement very, very soon about changes to the regulations, thanks to the Civil Justice Committee and others and their tireless work over the last few years to improve the situation as per Sir Rupert's original suggestions, because Sir Rupert noticed a lack of efficiency in CFAs, is that right?
Correct. CFAs, in my view, discourage efficiency for two reasons. First, the more billable hours you do, the more inefficiently you work, the greater the base costs which you recover. Secondly, since the success fee is related to the amount of base costs, perhaps half base costs, perhaps 100% of the base costs, the more inefficiently you work, the larger the success fee you recover. It seemed to me that conditional fee agreements incentivised inefficiency, whereas damages-based agreements incentivised efficiency, swift working and getting the best results you can for both the lawyer and the client.
I would say that one of the challenges, and Sir Rupert mentions this in one of the volumes that he co-wrote, is there's also a difference in incentives from the viewpoint of the clients and the lawyers. In small cases, the lawyers would like CFAs, the clients would like a DBA. In contrast, in big cases, the client would like a CFA and the lawyer would like a DBA. And that's a very difficult conflict to try to resolve.
Yes.
Mm-hmm. And Dominic, in the numerous solicitors that you've spoken to, what are the kind of objections they've come up with DBAs? That
Over and over again, it's simply that we take all of the risk, and that can't be right. The client gets a free ride, they can take advantage of us, we're out of pocket, we're working for nothing. And magic circle firms, we're not just talking about mainstream people, the grandest of the grand have said to me, we're not doing it. Yes. But as you referred to potential reform, which I think is coming, and that is going to completely transform the landscape.
In addition to the reform, obviously funders like Legis are trying to come up with their own toolkit approach of different risk mitigation solutions, which we hope will encourage the take-up of DBAs.
Yeah, I'm curious though, back to the US side, is there any data on whether most contingent fee arrangements on an all or nothing basis, or is some sort of blended hybrid DBA type model more common?
Oh, it's virtually all, at least in the personal services sector, it is all or nothing. In the corporate sector, it's a mix. One firm I spoke with basically preferred the equivalent of the hybrid model, where it's a mix of a low hourly combined with a percentage of recovery.
Sure.
Another firm I spoke with, does both and is very happy to do full contingency if there's sufficient support for it within the firm, and presumably if the amount that's potentially on the upside is high enough.
Can I just make one point? Sorry.
Yeah.
In this jurisdiction, Sir Rupert was very keen to protect personal injury claimants, and therefore the take allowed in injury is lower than in anything else. So I don't see, that may not be relevant to your clients, but I don't see DBA reform changing injury practice, but for commercial, mainstream, absolutely it will be transformational.
I think that DBA reform will be widely used in commercial disputes, as Dominic says. I also think it will be used in other high-value cases because the funds are sufficient to make the project worthwhile. Thirdly, I think that DBAs could have a value in very small claims where you have a lot of them clustered together to form a group action.
I think it sounds like with all of it really comes down to options available to the firm and to their client to create the best possible economic and incentive alignment situation as they can. And one thing that strikes me, maybe we can finish on this, is just the US regime opted for kind of maximum flexibility. The UK regime opted for it's either hourly rates or only if you fit within these little buckets. Do you think, and we haven't seen anything yet, but do you think introducing hybrids will start to widen those buckets out so they become one bigger bucket within which you have a lot more flexibility now to arrange what's best for client, lawyer, and what they're trying to do, or will it stay relatively constrained within individual buckets?
My answer to your question is yes. I think that we've got to maximize the various methods of funding which are available. I've never said that DBAs or hybrid DBAs were the be-all and end-all. I've put forward a package of proposals which includes a multiplicity of ways of funding actions so that the lawyers and the clients can agree whichever is appropriate. Sometimes they will agree an all-or-nothing DBA, sometimes a hybrid DBA, sometimes a CFA, sometimes third-party funding, or whatever. We need to maximize the available options.
In the commercial client area, there probably is an argument that regulation should be as minimal as possible on the grounds that you're dealing with sophisticated parties and let them figure out what works for them. I think there may be more of an issue in one of the areas that Sir Rupert mentioned, and that was in the mass action area where you don't have a sophisticated client. There you probably need much stronger regulatory oversight.
I agree.
Yeah, but the more options, the more options of funding you have, the more plates at the buffet. And so what? I mean, it's great that you have the range.
Well, I think that works both ways. We certainly take an option-oriented approach to how we try and help law firms and their clients finance or mitigate the risks of DBA or any arrangement that they have. And certainly having clients that are able to choose from a range of options of arranging their relationship with the client would only lead to better access to justice, better alignment of interests, and I think better outcomes for both clients and lawyers involved. But with that, we've kept you here a long time today, and just want to say thank you very much again, and thank you for chatting to us now.
Thank you very much.